Hey, hello, everybody. Here we are again. And why are we here again for the second time this week? We are here because our previous live stream didn't make it and we got rudely interrupted. Isn't that something? So I was sitting here yesterday in exactly the same space and I was delivering the session really nicely and kind of enthusiastically going around all the questions, all my SRA SQE1 MCQs, and then puff, the computer went dead and it decided to switch off and start again, which I did not enjoy at all. And now the follow on to this little problem is that I tried to log in with a phone. So I thought, okay, the computer has crashed. I'm going to use the phone to come back on. But guess what happened? The stream had stayed open. And because YouTube was still displaying the stream with no feed from me because the computer was off, it wouldn't allow me neither to close it nor to start another stream. So I had to figure out a way to come back in. Isn't that something? To come back in through the same stream and continue the discussion. By which time it took so long that I decided to give up and give you guys an alternate date and come back today. So hopefully today the computer can stay alive for long enough for us to do our stream properly and kind of enjoy ourselves. So perhaps it gives the opportunity for a crowd that is not available on Wednesdays to catch us on this Thursday. So normally our why am I using my offensive cups? I should I should be using the nicer cups than those ones. So what normally we have our live stream on Wednesdays at 1 p.m. Where the community gets here. We're having our coffee together while we're attempting MCQs. Today, obviously, we started a little bit later. It's like 1:30 on a Thursday. I do the occasional one-off live streams on different dates as well to catch different parts of the community that cannot be there on a Wednesday. But our standard deal is what, ladies and gentlemen? What is it? It is Wednesday at 1 p.m. And what we're doing every Wednesday at 1 p.m. is to go through the SRA's sample of SQE1 MCQs. And everybody can say this together. We've got some people watching us live. Go on. Write it in the chat. Why are we going through the SRA's sample? I'm waiting. The reason is that's the only official source of MCQs that we have, because the SRA and Kaplan do not give us past exam papers. So if we want the most accurate impression of what questions for the SQE are like, the only thing we've got to go for are the questions that we're getting from the SRA in their samples. So what I do with you guys, I take you through all these questions one by one, and I explain why the correct answer is correct, why the wrong answer is wrong, and then offer like a sort of mini lecture on the topic of the day or the topic of each question to make sure that everybody understands the substantive content, and we go like this. Now, I will pick up what I've left off yesterday. Hopefully, this is going to work, because as I'm talking to you guys here, I see a bit of lag on the video. So this is precisely what it did yesterday before it went kaput. Now, hopefully the same thing's not going to happen. Maybe the problem is the Wi-Fi in here. I don't know what it is. But okay, let me attempt to share my screen. Yesterday, we had completed section 47 out of the SRA sample, and we were moving on to question 48. So we're going to start again today from question 48, and hopefully we can do it. If the thing crashes again and logs me out, then I give up, and I'm just going to come back next week. So let me see if I can share my screen here. Okay, so you guys can see the question. Okie dokie. We have attempted to share the screen. Now you have a mini Greek man sitting in the corner, and you are seeing question 48. So without further ado, let's get to it and attempt our question. Right. Now, can I hide this? Okay, dokie. Question 48. 4 chartered surveyors have set up together in business as a limited liability partnership. 2 of them are designated members and 2 are ordinary members of the LLP. They all work full time. The members all meet formally once a month to discuss profit and loss, cash flow, and financial forecasts. This financial information has indicated that for the past 12 months, the LLP is not doing very well and it's unable to pay its debts. It has continued to operate, however, and the members have discussed ways of limiting costs. As a result, they've made some considerable reductions in expenditure. At one specific meeting a few months ago, one of the ordinary members suggested that they should obtain financial or legal advice on their position. This suggestion was rejected on the basis that it would make things too expensive. A liquidator is subsequently appointed and to take care of the insolvent winding up of the LLP. The liquidator considers it clear that at the date of that meeting, there was no reasonable prospect that the LLP would avoid insolvent liquidation and is considering whether to bring a claim for wrongful trading against all the members. Which of the following of the ordinary member which of the following must the ordinary member show to establish a defense against the claim by the liquidator? Now, first of all, a little bit of context here. In insolvency law, the relevant legislation here is the Limited Liability Partnerships Act of 2000 and also the Insolvency Act of 1986. If the people who run the show, be it the directors of a company or the members of a limited liability partnership, if they see that the business is not doing well and there is no realistic prospect that the business will recover, then they are under an obligation to start thinking about the interests of the creditors and wind down the business in a structured way to minimize potential losses for those creditors. What they are not allowed to do is continue to operate as if everything is hunky-dory and ramp up the debts and ramp up the costs and minimize the opportunities for the creditors to actually recover any money at the end of the day. If they do this, if they continue to spend money and enhance the losses without any interest in the position of the creditors, then they might be asked to compensate themselves to the money, to the assets that the company has towards paying its debts. So this is, in a way, an exemption to the rules of limited liability, because if the people in charge are engaged in wrongful trading, then they have to make contributions out of their own personal assets in order to resolve the asset problems of the corporation. So the question here is, by ignoring the sort of dire financial and deteriorating financial position of the LLP, have these members here engaged in wrongful trading? So you are asked to figure out which of the following positions the ordinary member must show to establish a defense against the claim by the liquidator. So is it A, that he took all reasonable measures to reduce expenditure incurred by the LLP? Is it B, that as he is not a designated member, he benefits from limited liability and cannot be required to contribute to the assets of the LLP? Is it C, that he took every step to minimize the potential loss to the LLP's creditors? Is it D, that it was reasonable for the LLP to continue trading in the expectation that the business would recover? Or is it E, that he is not a designated member and he did not have access to all the information necessary to decide whether the business was insolvent? Now, in order for you guys to answer this effectively, you need to be able to distinguish between what is a designated and an ordinary member. Now, in the context of a limited liability partnership, the designated members are the ones who have got the sort of bureaucratic and administrative responsibilities to report stuff back to the authorities, communicate with HMRC, and all the rest of it. Ordinary members are the people who are not tasked with these administrative tasks, but they are still expected to fully participate in the running of the limited liability partnership. So the fact that you're a designated member, it means that you're a point of contact for administrative queries, but it's not the same as saying that you're a director in a corporate structure. So the ordinary members are not the sort of non-executive directors that sit in the background and do nothing. The reality of the matter is that they all continue to be partners, and they're all equally responsible for what's happening in the partnership. Therefore, whether you're a designated member or an ordinary member is not going to determine whether you might be liable on a charge of wrongful trading or not. It depends what you have actually done. So if we're trying to pick the correct answer with that in mind, we're trying to pick out somebody who has not engaged in wrongful trading in the way that the provision is actually defined. So the only one that actually does this from our available options here is C. The ordinary member must, to establish a defense against the claim by the liquidator, the ordinary member must show that he took every step to minimize the potential loss to the LLP's creditors. This is option C, okay? Option A is incorrect. Because it's not just a matter of reducing expenditure. It's a matter of thinking about how the business can survive and thrive in the future and meet creditor demands. B is wrong because it makes a false distinction between designated and ordinary members. E is wrong for the same reason. Now, D says it was reasonable for the LLP to continue trading in the expectation that the business would recover. It's not only that. It's not that without doing anything you think is going to do best. It means what steps did the person actually take to make sure that the creditors' losses would be minimized. The reason for this is that once a company enters in a pathway towards insolvency, then the objective of the management shifts from the interests of the company to the interests of the creditors. Because you might be thinking C, that talks about the creditors, and D, that talks about the LLP, are probably both correct because they're along the same lines of thinking. What you're missing is that the Insolvency Act requires people to shift the mindset towards the interests of the creditors at that point in the company's life, in the company's or the LLP's life cycle. That's why C is the correct answer. Now, I don't know what you guys think. We've got some people watching us live. Would you consider this to be an easy question for you to attempt, or does this go beyond the stuff that the average person would know? I'm so and so with it because I know the insolvency stuff well, and I've been teaching kind of business and company law for a very long time. But I do appreciate that this tends to be a niche area of the law, that unless you're very well involved in corporate structures and corporate decision making and you're concerned about the consequences of corporate failure, these may not necessarily be areas that you have studied in length in the past. I do have some videos specifically on insolvency, the consequences of insolvency, and how one can protect themselves if they think that the counterparties are getting close to an insolvency event. So feel free to go have a look around this channel to look at those videos. But this is very much the standard domain of FLK business law. If you are preparing for this, which you have to, it's not like you have a choice, right? If you're preparing for FLK1 and you're preparing for FLK business law, an understanding of what happens in insolvency, how the incentives of the various parties operating within a corporate structure, what they need to do to prepare and so on, I think it's going to be beneficial. So even though this might come across as a kind of slightly boring area of the law in some cases, I would advise that you guys pay a little bit of attention to this, because it's not really that it's complex, but if you've never heard of it, it becomes a little bit difficult to navigate. So let's move on and see something slightly different. I would like to say thank you to one of our new channel members. We've got, I'm probably going to murder the name here, so apologies for this. We've got Gursimar, who has joined us as a paid channel member. So thank you so much for your support. You can all become paid members of the channel for less than the price of your average coffee. So for $2.99 a month, you can support the channel, and as a result, you get access to all the videos that are queued up to publish. So a new video is coming out every Saturday. For those who are paid members, you can see all of those videos that are waiting in line straight away without having to wait, which can accelerate your preparation. I also do the occasional live streams that are for members only, and there are various other things that members are getting. So if you're going down that pathway, thank you so much, guys, for your support. But our kind of weekly MCQ live streams are going to remain free for the entire community, so we can help as many people as possible. So let's have a look at question 49. To progress a case before the court, the correct interpretation of a section in a statute is required, and the judge considers his options under the rules of statutory interpretation. He decides to use the mischief rule. Which of the following best describes how the judge will use the mischief rule in interpreting the statute? Will he A, consider the defect in common law which caused Parliament to pass the statute, or B, select an interpretation of the statute which addresses any initial absurdity, or C, refer to the record kept by parliamentary drafters who worked on the statute? Is it D, give the words of the statute their ordinary and grammatical meaning? Or is it E, make use of an academic textbook as an external aid to interpretation? So this question is one on statutory interpretation. And what you have in your potential answers here is a list of the various approaches or methodologies that the courts can employ in interpreting what a statute is trying to say. Now, clearly, we're looking at a specific one, but all of these are established methodologies. So interpreting the statute that does not result in an absurd outcome is a perfectly legitimate technique. Thinking about the intention of the parliamentary drafters and the processes of law reform and what the bill went through in the various stages in understanding what the statute was trying to achieve is also fine. If we're staying within the ordinary grammatical meaning of the statute, that can give a very simple solution on occasion. Now, if there is a real ambiguity or concern about the state of the law in this area, then the courts can use expert evidence, including academic commentary, to guide them in their decisions. However, the mischief rule means something specific. And for that, we only have one correct answer here, and that is option A. The judge will consider the defect in the common law which caused Parliament to pass the statute. In that context, we interpret the word mischief to mean problem. So what is the flaw? What is the fault? What is the problem that the courts are trying to fix, that the Parliament, that the legislator was trying to fix by including that section? And very often we have statutory sections that are meant to correct either pathways that the common law took that they're not considered appropriate anymore, or to deal issues of ambiguity that have plagued the courts for a very long time. So this is like one of the key motivators behind law reform, and a lot of the work of the Law Commission goes in that direction, in making sure that problematic understandings or problematic interpretations of the law are fixed through statutory involvement. So there we go. I just finished a long and amazing lecture on the English legal system. So it took me forever to put this together, because normally I kind of put new lectures for you guys on the YouTube channel with a degree of regularity, so we have like fresh content for the community. But that one took me weeks and weeks and weeks. But I've ended up with a really nice piece. So this is the latest one that's been published. It's available for paying channel members to view immediately, and it's on the queue for publication. It's going to come up for the whole community at some point and towards the end of December. So this is like an hour-long lecture that explains the the key fundamental points about the English legal system, constitutional law, human rights, the link between the various devolved assemblies and different powers to make decisions between England and Wales and all of that stuff. So I'm really happy with it, and I think it starts off also with a very funny way that has got me carrying around a fish. Like a big live salmon. So if you guys are interested in kind of funky visuals as well, then that lecture is definitely good for you. Now, how do you feel about all this, by the way? Do you do the videos that have got fancy visuals, do they attract you? Are you likely to watch those more than the others? I've been experimenting with improving the quality of the video visuals that I put to kind of accompany my lectures, and I'm getting some good results out of the latest set that I've done. So the videos that I've been publishing over the last couple of months are doing a lot better. So maybe it is that the people find these topics attractive, or it could be that the kind of more elaborate visuals that are going in there are nicer. So if you like the visuals and you would like me to invest more time in kind of putting fish and kind of animals and stuff in the lectures, give me the thumbs up. If you're watching this on the replay, also give me the thumbs up. Then I will take positive messages through thumbs up and comments as a license to continue to make videos with me carrying stuff around. Yes, that's what we're gonna do. I do have another video where I'm carrying around. What is that I'm carrying around? I'm carrying around a peacock. Did you see that one? That I'm walking around chasing a peacock. Yes. So that's also, I think it's the tort video. One of the more recent videos that are queued to publish in the next few weeks. All right, so this question 49 from the SRA's set was the question that we had on statutory interpretation and the mischief rule, which means the problem that Parliament is aiming to solve. Let's see what question 50 is about. Oops. All right. Question 50. And I just had an idea. I was thinking of bringing one of my digital avatars to participate in our live sessions. And I just realized that in the same way that I'm sharing the PowerPoint, I could share the screen where the avatar is on and attempt to have a discussion with the avatar that way. So I'll workshop this a bit and see if I can do it. You never know what's gonna happen. Maybe we're gonna come up with a format that actually works and you guys like to watch. Question 50. A woman is driving her car along a road when she sees the warning light indicating low oil engine. Low engine oil. Yeah. The woman stops the car at the side of the road and turns on the car's hazard warning lights. A passing motorist sees the woman and stops to offer assistance. The motorist has some spare engine oil, and the woman agrees that he should pour some of this into her car's engine. The oil warning light turns off. The woman assumes everything's fine. She drives off, but about 20 minutes after, her engine seizes up, causing considerable damage to the car. A garage carries out repairs to the car. She is told that the motorist had used the wrong type of engine oil, and this has caused engine damage. The woman wishes to bring a claim in negligence against the motorist. She seeks advice from a solicitor who believes that there are no similar precedents or comparable cases by which to establish whether the motorist owes the woman a duty of care. The solicitor's legal advice about what the court will consider is based on this belief. Some solicitor. Don't be that solicitor. What legal advice will the solicitor provide about what the court will consider when deciding whether the motorist owes a duty of care in negligence to the woman? It's kind of peculiar. That's a peculiar question, don't you think? It's like, why does it need to tell us that the solicitor basically makes a mistake at the beginning? I'm not so sure. So the question is, yes. The question is, what legal advice will the solicitor provide about what the court will consider when deciding whether the motorist owes a duty of care in negligence to the woman? Is it A, solely whether the motorist could reasonably foresee that harm would be caused to the woman's property. B, solely whether the motorist had the relationship of proximity with the woman and whether it was fair, just, and reasonable to impose a duty on him. D, or C, did I say C? C, solely whether the motorist could reasonably foresee that harm would be caused to the woman's property and whether he has a relationship of proximity with her. D, whether the motorist could reasonably foresee that harm would be caused to the woman's property, whether he has a relationship of proximity with her, and whether it is fair, just, and reasonable to impose a duty on him. E, and that's the final one, whether it is fair, just, and reasonable to impose a duty on the motorist to the woman. What? Whether it is fair, just, and reasonable to impose a duty on the motorist to the woman. Right, fair to the woman to impose it. I think whoever drafted this must be having a bad day, yeah, because there are a few things. I know that this is the SRA sample, but I mean, come on, there are many things wrong with this question. Now, we are in the domain of tort law, and the question is asking about a duty of care. There are two grand categories that we need to keep in mind. Is the situations where a duty of care is imposed for a particular circumstance that is pre-existing, pre-identified. This is normally like statutory duties of care. For instance, the duty that every motorist has to other users of the road. So this is not an ad hoc duty. This is a statutory duty implied by law to all the motorists. But we also have situations where a duty of care can arise in bespoke ad hoc circumstances when there is no pre-existing duty, like when you're driving a vehicle. A pre-existing duty exists if you're the occupier of premises, perhaps, for people not to be injured while they're in your space that you control. If somebody, however, is kind of minding their own business in a public space and they're close to you, and for some reason, due to their negligence, they cause you harm, there is no pre-existing category that can kind of hoover this up. In that case, we're talking about an investigation of whether a duty of care exists in novel circumstances. The key case that contains the tools to interpret this is the Caparo case. This is Caparo Industries versus Dickman. It's a case from 1990. You know, I like that because, you know, I used to be a student in the 90s, so I'm very partial to cases from the 90s. So the Caparo test requires certain things. This is what the question is about. It's about to test whether you know about the requirements in the Caparo test. And all the questions here, A, B, C, and E, are components of that test. The only potential answer that contains all the components of the test together is D, where it's got them all together. So we need proximity. We need harm to be caused to the woman coming out of the action of the person. And it needs to be fair, just, and reasonable in the circumstances to impose the duty. Okay, so there has to be a relationship of close proximity. Harm needs to have been caused by their actions. It needs to be fair to assume the duty in the circumstances. We need to have all the causal links that tie everything together and so on. So this is a terrible question because if you know about the Caparo test for establishing a duty of care in ad hoc circumstances, it is none of these things in isolation. It's all of them together. And the fact that A, B, C, and D just say solely, and only one has got all of them together, it's a kind of dead giveaway that the correct answer is D, isn't it? There we go. This is my hope for you. I wish that when you take SQE1, all the questions are going to be as easy as this one. Perhaps the difficulty here comes from the fact that the scenario is so long. So it's like a very chunky scenario, which is going to waste your time to read it, because remember, you've got less than 2 minutes per question. Yeah, less than 2 minutes. So by the time you kind of work your way through all of this, you probably spend more time and you've got very little time available to think, but there we go. Otherwise, in terms of content, I think the question is both poorly written and the answers are probably fairly obvious, right? So the correct one here is going to be D. Thank you, SRA, for giving us an easy question in the form of question number 50. Okay. So let's see. 47 we had done yesterday before we got interrupted. 48 we started doing and we finished off today. We've moved on to 49, 50, and now we are going on to question 51. Let me just try and scroll to that one. Now, if you guys are dying to get more questions, so you just love SQE style MCQs and you cannot have enough of them because you've been listening to me, and now every time you pick up a cup of coffee, you're thinking, coffee? I gotta do an MCQ because Dr. Yannis said every time I stop for a coffee break, I should be doing MCQs in order to prepare for the SQE. So if this has been kind of drilled into your head and you're dying to find more MCQs, where are you going to get more MCQs? I've got a solution for you guys, and you don't have to put any effort in this at all. What you need to do, email news, let me spell this, it's not going to help, newsletter at glintis.co.uk. Email this with the word subscribe in the subject matter, and I'm going to add you to my mailing list. Every Monday, I'm going to send you a fresh SQE1 style MCQ for you to try at home. What I'm going to do as well, I'm going to give you the answer to the previous week's question with a full explanation as to why the correct answer is correct and why the wrong answer is wrong. I'm also going to give you reading material or a video to watch that helps embed your understanding of the substantive area of the law that the question is about. And I'm going to give you a bunch of discount codes so you can get discounts if you go and buy books from Revise SQE, if you want to take advantage of the MCQ database and the law tutor from Law Drills. Other things that I've negotiated deals from time to time that give you nice discount codes. So you're going to get the MCQs that you're after. You're going to get things to study to embed your understanding. You're going to get discount codes to save you guys money. And you're going to get all of this on the newsletter every Monday without fail. And all of it is free. Yeah. Isn't that great? So then when you stop, you're going to have to wait to receive the newsletter. I send it every Monday, but I send it at random points. Okay, I don't have a specific time for it to come out because I'm sending it manually. So you're gonna have to wait all Monday, coffee in hand, and the moment the newsletter hits, then you're gonna be like, "Booyah! Yannis sent the newsletter. Let's have a cup of coffee and attempt the MCQ." That's what you're gonna do. Okay, that's what your life is gonna be from now on. It's gonna be coffee breaks and MCQs again and again and again and again, till you hit your SQE1 sitting and pass, and then put all this nightmare behind you. Yeah. Are you guys trying towards the January sitting of SQE? If you're from the people watching us live, it would be awesome if you let me know in the chat. If not, feel free to put it in the comments. And I can reply to you afterwards. So if we have you here preparing for January SQE in 2026, then we're getting close. So you're gonna ramp up your prep, get your hands onto as many MCQs as you can. If you are preparing for July, we can take it easy, but we still got, you still have to put the prep in, but you got a little bit more time to go. Also, if you start your preparation now, probably not for January because it's too short, but if you're starting your preparation now, looking forward to July, go to my website. And this actually comes with a newsletter as well. I've created an adaptive study planner. So this is like a little app that works on my website. You put your preparation starting date. You select whether you want to sit FLK1, FLK2, or both. You select your target examination. Is it going to be July or is it going to be January? And the app has the syllabus, the FLK, pre-programmed inside, as long as with something that I made myself, like a weighting of how difficult the subjects are. So it's going to then spread out the totality of the FLK across the weeks that you've got available, and it's going to tell you what you should be studying every week to give you enough time to cover the totality of the FLK from the point that you start your prep up until the point that you have to sit the exam. It's going to feed in some rest weeks and some revision weeks and stuff like that in there. And it spreads out the FLK, knowing already what are the difficult subjects that you need to spend some more time on. So when you get the newsletter on Monday, go to the app and give it a shot and let me know what you think about it. I'm still testing it out to see what people think. But I think it's going to be a useful contribution, especially if you're self-studying. So you need to organize all these stuff and make a calendar for yourselves and so on. I think the app can be very helpful. If you're with a prep school already, then the prep school already has probably given you a syllabus that you need to go through and has given you like a calendar and a schedule to help you do it. So in any event, go through the app. If you're a self-studier, it's going to help immensely. If you're already with a prep school, it's probably going to reinforce what you're doing anyway. Okay, question 51. Yeah. All right. A limited company supplies bike stands at a cost of £15,000, including VAT, to a sole trader who sells electric bikes. The defendant is VAT registered. The defendant fails to pay the amount due. The claimant instructs a solicitor who obtains a money judgment in the county court for the full sum plus interest. The defendant does not pay the judgment debt within 14 days as ordered by the court. The claimant accurately informs the solicitor that the defendant rents a very expensive apartment. Her business is doing well, and she also lists an industrial unit when she sells and stores all of her stock. She also pays money monthly into a bank account in the joint names of her and her spouse, which has a current balance of £30,000. Okay, all of this is like quite a lot of fluff, right? And we're getting to a kind of unexpected request. What is the best method of enforcing the judgment to recover some or all of the judgment debt? Aha. Is it a warrant of control? Is it an attachment of earnings order? Is it a charging order of the apartment? Is it a third-party debt order? Or is it a writ of control? Now, to be honest with you guys, I wouldn't know how to answer this question. I've been teaching this stuff for 20 years, and money judgments and kind of that part of civil procedure process is not something that I have come across. All right. So in order for you to be able to effectively answer this, you do need to have a level of understanding and engagement with that part of court procedure that has to do with enforcement and who to send to pick up to try and retrieve the assets from somebody who has an order against them and is in default. Now, there's only one correct answer here, which you would figure out if you look this up. The correct answer is E, a writ of control. What is that? That is a high court document. This allows an enforcement officer to seize and sell the debtor's assets. So why is this a preferred option than some of the others? Because this gives greater leeway to the enforcement officer to select from available assets in order to satisfy this debt, as opposed to taking possession of any particular asset within those. So I didn't know about this. You didn't know about this. Probably nobody knows about this unless you're actually working for a debt collector, or whether you are in the unfortunate position of having to prepare civil and criminal procedure in the context of the SQE. But yeah, so that I find this particular question to be difficult, and also having it popping up in the set for FLK1 is a little bit unusual. So today's set, or actually this week's set, if we're starting from what we did last week, from question 47 all the way to question 51 from the SRA's sample, I think is a very mixed bag. I mean, there are some that seem to be dead easy, and there are some that seem to be in the really niche areas of the law that don't seem to come up very often. Now, having said that, there are so many questions. There are 180 questions that they can put in the SQE if you count, and if you count FLK1, FLK2, there's plenty. So they do have the space to actually ask you questions about absolutely everything. Do you need to have the correct answer about absolutely everything? No, you don't, because if you're scoring, say, 60%, then you're probably in a good space to pass overall, considering how horrible the results are getting. So you don't need to get the correct answer for absolutely everything, but obviously the higher you score, the more correct answers you have, the better it gets. Now, hopefully this has been useful for you guys. Thank you very much for turning up for the second time this week after our unfortunate IT problems yesterday. I've enjoyed having some people watching live. Thank you very much for your support. Thank you very much to the channel members who are paying channel members who are supporting this channel. I will see you guys next week, Wednesday, for our next MCQ live stream. Up until then, keep well and keep studying.